Hi everyone, welcome to Module 4. We'll be discussing the key clauses in commercial contracts. Now, in this module, we are going to focus on your building blocks of every business agreements, the clauses that define your rights, responsibilities, and even the risk. So, I guess let's dive straight in. Let's start with why these clauses actually matter. So, no matter what your contract is, how big or small, it is built out of these clauses. Think of them as your DNA of an agreement. They define what does what, by when. It also talks about what happens if something goes wrong, or how the problems are solved, and how the risks are shared. So you can think of it like building a house, which is equivalent to contract. Now each house is made up of bricks. These bricks are your clauses. So weak bricks or your vague clauses may make the entire structure collapse during a storm or a dispute or breach. So to keep it simple and easy to understand, always remember the bad clauses, they will always lead to ambiguity, confusion, and legal battles, while the good clauses, they ensure clarity, smooth execution, and legal protection. Let's move with the first clause. That's the scope of work. Now, this clause, it defines what the service provider is agreeing to deliver. Now, it is your foundation of the contract. You can see the sample format here, where it is mentioned that the service provider shall design, develop, and deliver a five-page responsive website, including a homepage, contract form, and blog section. So, what is basically your checklist of what all you should include in your scope of work clause is the quantity or the output that is expected. It could be 5 videos, 20 designs, whatever that you're expecting. Then it talks about the platforms or the tools that should be used. And lastly, it must mention the milestones or the timelines for the delivery. Now, what this clause does is it eliminates the guesswork. So, if it is vague, the client may 10 deliverables while the provider is just thinking of three. Now, and this is how your dispute will begin. So it is very important to make sure you're including the right things while drafting your scope of work clause. Now let's talk about the payment terms clause. Now this clause answers when, how, and how much will the provider be paid. Now the elements you must include here is the pricing model. That is, it could be a fixed fee, hourly fee, or the milestone-based fee. The mode of payment, it could be through bank transfer, UPI, PayPal. You can also mention the schedule. I mean, you must include that. Example, if it is a weekly payment or 30-day cycle billing. And lastly, the penalties in case of late payments, if any. So you can see the example that I've mentioned. The client shall pay 25,000 rupees in total two installments, 50% when and 50% then. So this is how your payment terms is drafted. Now, this clause, what it does is it protects the provider's cash flow and also the client's expectations. Now, let's talk about the term and termination clause. Now, this clause has two parts. The first part is term as clear. So, this tells how long the contract will last. And the second one is a termination, which states how it can be ended. So, you can take, for example, of the term clause, it can be drafted as this agreement shall remain in force for 6 months from the effective date. And talking about the termination clause, you can mention either party may terminate the agreement with 15 days prior written notice. So, what all should be specified in your termination clause? It should specify the notice period. It must mention the grounds for termination. It could be your breach or insolvency. It also should mention what happens post your termination. You should do you have to return the materials, the handovers, what happens in case of unpaid dues. So all of this must be mentioned. So in total, your termination clauses, they create your exit routes, and without them, you're actually trapped in a bad deal. So everything should be thought of while drafting the termination clause. Now let's talk about the confidentiality clause. Now this clause, it protects the sensitive business information like your trade secrets, the client data, or the strategies, or even your pricing models. So what all must be included here? It must include what classifies or counts as confidential information. It must mention the duration of your confidentiality, example, 2 years post the contract or so on. And it also must include exceptions when the information is to be disclosed, for example, court orders for the same. In simple terms, it's about keeping things private even after the contract ends. Now let's talk about the intellectual property clause. So the IP ownership clause, it clarifies who owns the final product. It's extremely important in contracts that involve content, design, software, or even invention. Now there are two common options in your IP ownership clauses. First is that the client owns the deliverable once the payment is made, and the second one is the service provider, it retains the ownership and gives a license to the client. So, samply you can craft it as all the copyrights in the final logo design shall be assigned to the client upon the payment. So, it is also important to understand that you must also clarify when the ownership transfers on delivery or on payment or on both. You must always state all these things. Never let it be assumed, or let the parties or quote to assume things. You must always state things to avoid any confusion. Now let's talk about your dispute resolution clause. So no matter how airtight your contract is, disputes still do arise. Now this clause tells us how to solve them. So the standard flow is usually your negotiation or mediation, or you go to the court. So you must here always add your jurisdiction clause. Now what this does is it decides which country or the city's court will hear the case if things go that far. So this also becomes very important in case of your cross-border deals. You can refer to a sample here that all the disputes that are resolved through will be resolved through binding arbitration in New Delhi, where we've mentioned the jurisdiction, and we've also mentioned that it will be resolved through arbitration, and also mentioned the legislation that will that will play its role in case of arbitration. Now let's talk about the indemnity clause. So this clause actually covers the financial risk. Talking about indemnity, it means one party will cover the other's party laws for specific events. It could be IP infringement, it could be negligence. Then is the limitation of liability clause, which caps the maximum compensation that is payable. Take for example, the service provider's liability shall not exceed the total fees paid under this agreement. Okay, now let's quickly summarize the essential clauses. One is your scope of work, which tells what's being delivered. Then is your payment clause, which tells how and when the money flows. Then is your termination clause, which tells how to exit the deal. Then is your confidentiality clause, which tells you what must stay private. Then is your IP ownership clause, which tells who owns what's created. Then is your dispute resolution clause, which tells how the problems are solved. And lastly is your indemnity clause, which tells who bears the risk. Now, it is important to note that clauses are not just your legal jargons, they are your practical tools. Now, each one has a specific purpose, which is to protect, to clarify, and even enable smooth business. So, you must understand them, negotiate them, and read them very clearly, because in a world that is full of contracts, what you don't say can hurt you.